How to make a Freedom of Information request in Nigeria. Right to request information. The Freedom of Information Act 2011 gives everyone the right to request information, whether or not contained in any written form, which is in the custody or possession of any public official, agency or institution howsoever described. The person requesting the information does not need to show any specific interest in the information or justify his or her reasons for making the request. What information can be requested? The Freedom of Information Act provides that individuals have a right to request any recorded information held by a public authority. Recorded information is and restricted to information that is in written form, but also information or records that does not exist in print but can by regulation be produced from a machine. Who can you make a request to? You may request the information or record from any public official, agency or institution. This means any legislative, executive, judicial, and administrative or advisory body of the government, including boards, bureau, committees or commissions of the state, and any subsidiary body of those bodies including but not limited to committees and subcommittees which are supported in whole or in part by public fund or which expends public fund. It also all corporations established by law and all companies in which government has a controlling interest, and private companies utilizing public funds, providing public services or performing public functions. How can I make a request? 1. Orally, an applicant may make an oral request to an authorized official of a government or public institution, who must then reduce the application into writing and provide a copy of the written application to the applicant. 2. In writing. 3. Through a third party. Illiterate or disabled applicants who by virtue of their illiteracy or disability are unable to make an application for access to information or may make that application through a third party. Is a request free of charge? The only charges for a request are limited to standard charges for document duplication and fees transcription where necessary. What happens after a request is made? The law provides that the public institution must make the information available within 7 days of receiving the request. Failure to give access to the information requested for, within the timelines provided by the Act, is deemed as a refusal of access. These are the potential outcomes. 1. Information provided. The public institution provides the requested information to the applicant within 7 days. 2. Extension. The public institution may extend the timeline for a response for a further time not exceeding 7 further days, where the application is for a large number of records and meeting the original time limit would unreasonably interfere with the operations of the public institution. Consultations are necessary to comply with the application that cannot reasonably be completed within the original time limit. 3. Request transfer. The institution may transfer the request to another department or agency, if it is of the view is that another public institution has greater interest in the information, may within 3 days but not later than 7 days after the application is received, transfer the application to the other public institution, and give written notice of the transfer to the applicant. 4. Part disclosure. The institution may disclose part of the information requested if the other part is exempted from being disclosed by virtue of provisions of the Freedom of Information Act. 5. Rejection. The institution may refuse to give access to a record or information applied for. When this occurs, the institution shall state in the notice given to the applicant the grounds for the refusal, and the specific provision of this Act that it relates to. Also, the refusal must state whether the information or record exists, the names, designation and signature of each person responsible for the denial of such application,